Good afternoon, everyone. Thank you very much for taking your time to log into yet another Clinix Health Group webinar. For those who are new to the family, the Clinix Health Group is a group that is a company that owns a few hospitals, 8 hospitals all in all. 5 of them acute care hospitals, 2 mental health care hospitals, 1 is a day hospital. And it started in 1992 and still going strong. We are grateful that the board and the executive of Clinix has been sponsoring these webinars since 2020, and they've gone from strength to strength since then. We've been running them every Thursday, except for a few Thursdays in between. So we're going on now for, what, 4 years? I think all thanks to you, because you are keen to learn and to, continuing professional development is a very important aspect of our practices for sake of the safety, quality of care we give to our patients. I think it's encouraging to see that practitioners continue to want to learn the latest from those who are experienced, those who are in the know, and people are ready to share information. People who present in our webinars are volunteers, actually. They don't do it for anything else except to knowledge management. May I ask everyone in the room to mute?
Dr. Kinoshi, please unmute yourself.
Okay, we will unmute everyone at the end of the presentation so that we can raise your electronic hand at that time after the presentation, and you can ask any question you'd like to ask or make any comment you'd like to make. In the meantime, whilst the presenter for this evening is busy, you will be muted, but you can go to the chat box and place any question or comment that you would like to make in the chat box. And at the end of the presentation, your questions and comments will be attended to. I was still saying about the presenters. The presenters do this for free for the love of knowledge sharing. And I think for that, we do thank them. The webinars run by Clinix Health Group are also free to the attendees and paid for by the company. The HPCSA offers CPD points for attendees. So we are accredited for CPD points with HPCSA. And you normally get confirmation of your CPD points allocated to your HPCSA profile in between 3 and 4 weeks. It used to take shorter, about a week in the past, but now, because of workload, you can imagine how many people are trying to get CPD points in the last 6 months or so, since HPCSA has insisted on continuing professional development. I think they're quite busy, so it takes about anything between 2 and 4 weeks. So please don't be impatient if you don't receive confirmation of your CPD points within a week or 2. We've been getting messages, and I've seen comments about that from some of the attendees. But those who do not receive confirmation of their CPD points within 4 weeks can always contact us. Let us know. We follow up on your behalf. as long as we have confirmation that you've attended the webinar. You can write to us at webinars@clinix.co.za. webinars@clinix.co.za. But for you to receive webinar CPD points, my apology, you have to register yourself on the link, because the link will ask for your name and surname, email address, but very importantly, your registration number with HPCSA. So if you receive the link second hand, if you receive the Zoom link second hand from someone who had registered, that person, of course, will receive CPD points, but you yourself won't get them. So you have to, only those who've registered and have inserted their HPCSA registration, or even South African Nursing Council, by the way, and a number, or even pharmacists. Some pharmacists do log in as well, and other healthcare professionals. So they just use whatever number they've registered with. They get accredited. But otherwise, if you get the Zoom link secondhand from someone who had registered, you will still be able to participate in the webinar, but you won't be, your profile won't be created as HPCSA. I think I should just make that clear, because it has caused some confusion with some of our attendees. So for now, let me introduce the speaker for today. Our speaker today is Dr. Pinky Chirwa. Dr. Pinky Chirwa is a specialist pediatrician. She's also a specialist neonatologist. She has been working and is still working. She's been working at Nelson Mandela Children's Hospital since 2017, Dr. Chirwa. And I think since 2021, you've been the Director of Clinical Services at Nelson Mandela Children's Hospital. Before that, Dr. Chirwa has worked at Krisanibara. She's been in GP in Soweto, serving the community of Soweto. Before she specialized in, she decided to specialize in pediatrics at the VERTS, in MBSHB at Medunsa, but FCP with the South African Colleges of Medicine whilst she was at VETS, Krisanibara. She's also very keen and passionate about ethics, medical ethics. And as a result, even as she was a specialist in pediatrics and neonatology in particular, she attained a master's degree, science MSc in bioethics and law at Wits University in 2017. And she's also she's been a member of the board, member of the medical and dental board in the HPCSA for the last almost 10 years. I think she's into her 10th year now with the HPCSA. So she's gained a lot of experience serving in professional conduct committees and in prelim committees of the HPCSA. And hence her topic today on why doctors get reported to the HPCSA, and a very interesting topic for all of us who are registered with the HPCSA. And now you know why she chose this particular topic, which I think you will also add to your ethics CPD points, those who are running short on the ethics the CPD points. So she's also not new to Clinix. Dr. Chirwa, let me put it this way. Clinix Health Group works with sponsors the Clinician Service Excellence Awards. And in 2017, Dr. Chirwa won the Academic and Clinical Excellence Award from South African Society, I think in medicine and surgery. It's run by Professor Maswime, Salome Maswime, who's been running with it for some years. So she's also a treasurer of a trustee of United South African Neonatal Association. She's also a deputy chairperson of the Ronald McDonald House Charities. She's very active in the community, and she has presented a number of conference papers nationally and internationally. I think, Dr. Chirwa, over to you. I'll let you do your presentation, and we will mute on our side, but please, those who want to put in the questions so that you don't forget them, you can put them in the chat group, in the chat box, and we'll attend to them after the presentation. Thank you very much. Over to you, Dr. Chirwa.
Okay, thank you very much, Dr. Kinoshi, and thank you very much to Clinix first, and to all the attendees. The topic chosen was actually chosen as, I keep joking with my colleagues and say it's actually a gift from me. So I've been at the HPCSA board this is my 10th year. I think our term ends in October, and it came to my mind to say, I think I'll be doing an injustice if I don't share what I have learned through the 10 years. I'm starting with a disclaimer, and I'm going to end with a disclaimer. So the topic, I came up with it myself, and I am not here as a representative of the HPCSA. I'm just sharing my insights and my experience. The whole time that I've been with the HPCSA, I've served on Prelim 1. At first, the first 5 years, I was a member, and then the latter 5 years, I actually chair the committee. So any insights gained from that experience, I'm going to try and share with you. I haven't covered everything that gets reported. I selected the ones that stood out for me. So I will go through that sequence. So the outline of my talk, I'm going to start with an introduction of telling you a little bit about the HPCSA. And I've heard that my team members, my prelim members have joined. They said they're going to join. So if they are here, they are also welcome, and I'm sure they'll also add insight. Then we'll do a bit of background. Strangely, informed consent. When I was doing ethics, that was the most eye-opening document I've ever read. So I'll share a little bit, and then I'll speak about documentation. I'll speak about communication, which has become quite a problem lately. Then I'll speak about confidentiality, what constitutes negligence. There's a new thing on the block called social media. Just last week, I was chairing my prelim and I was in stitches because one of the doctors said, now we've got doctors who are influencers. I don't know what that means. And then I'm going to speak about fees. A bit of background. I've been a board member for the past 9 years. I chair the preliminary committee. Traditionally, this committee, I think before me, it was Dr. Titus. It used to handle quite a lot of the high-profile cases. Some of the cases you've seen in the media, but it's just traditionally like that. But it handles other matters as well. So we are a team of 8 members, a neonatologist, which is myself, and I chair, a general surgeon, an orthopedic surgeon, an anesthesiologist. We've got 2 family physicians, and 1 community representative vested in law. So you can tell that, I mean, our committee is actually quite broad, and the matters that get handled there sometimes leave us very baffled. We sit bi-monthly, and we handle, in the beginning, we handled an average of between 50 and 60 matters. We sit over 2 days, and I think the backlog is getting a bit better, so the matters have reduced. But on an average sitting, we handle about 40 cases. So I'm sure all this information, most of you know, because you're health professionals, and the HPCSA is actually a creature of statute, and it's governed by the Health Professionals Act. The 2 aims for the HPCSA is to protect the public and also guiding the profession. And I know a whole lot of people sometimes speak to me and they say, but HPCSA is always after doctors. And my standard answer is the same. We aim to protect the public, and sometimes when we do get called to the HPCSA, it's not to punish, it's actually to guide. There is a complaints handling unit where all the matters are reported, and they are handled in 3 ways. So your matter can just be dismissed at that level because that committee, the handling unit, already has professionals in it. And they are also vested in law and in medicine. So if a complaint is spurious or it doesn't make sense or it doesn't fit all the criteria of a complaint, they don't even pass it through to us. Then some of your complaints are then sent to the ombudsman for mediation, and we at the preliminary committees, we never even get to see them. And then the matters that the unit deems that there may be a case to answer, or there is something that can be ventilated, it then comes to us. Then when the cases come to the preliminary committees, there are 5 preliminary committees, they then are allocated to the 5 preliminary committees, depending on the types of specialties. Sometimes it's just more information required, and then the cases that are very serious, as determined by the preliminary committees, they are then sent to conduct inquiry. Then lately, there's another committee that has been added, which is the appeals committee for prelims. So if you, as a doctor, are disgruntled about a decision taken by any of the prelims, you can write back to the HPCSA or provide more evidence. Then what they will do, they sit and they look at the matter. So the people who sit in the appeals committee are not the same people that are in the prelims. They look at the evidence, they look at what the prelim had decided. They can either decide to uphold the decision of the prelim, or they send the matter back to the prelim to try and reconsider. So you can see it's quite a detailed process. So when we joined, we used to have cases like backlog up to 4 to 5 years. And I must say, I think I've seen quite an improvement. We probably are now dealing with cases from 2023 and 2024. The first topic I've chosen that we see mostly is informed consent. So I just put some components of what you need to consider when you speak to informed consent. At first, you have to have, so the person signing the consent must have capacity and they must have competence. So your capacity is determined by age, which is the adult age, or for children, we will see there's a difference between a child with capacity and a child with competence. And then competence is what is not really determined by us. It's mostly the psychologist, the psychiatrist, particularly when it comes to mental competence. So when you inform a patient about the treatment that you're going to give, it has to be full disclosure of information. You cannot hide everything. So if you are a surgeon, you're going to do a surgery, you have to speak to the type of surgery you're going to do, the complications envisaged, the fees. That is important. The patient cannot find out after the event that the surgery cost twice as much. Whether you are affiliated to medical aids or you have not, you are not affiliated. So basically you put everything. But the one thing I have noticed, because when you get reported, we ask patients to bring the consent form. So always see very interesting thing. So when you do informed consent, it doesn't help that you basically, I'll use what I have seen, where somebody just downloads the textbook. You may bleed, your stitches may come off, your wound can be infected. It's not really helpful for a patient who is actually distressed. So try and shorten it, but at the same time, it has to be full disclosure of information. And then you facilitate understanding for the patient. Most patients would say, the doctor just gave me a form when I was just entering theater and told me, sign here, sign here. That is not going to work. And it has to be voluntary. You don't have to coerce patients. Then the next point is informed refusal. I know a whole lot of people know it as RHT or refuse hospital treatment. Even with that, a patient has to refuse hospital treatment when they have been informed. It's not a matter of, so you don't want this surgery, just sign here and you go. And one thing we've noticed, our patients have become very wise. They read the internet, they Google, they will find every rule. So it's very interesting when we see complaints and they quote the ethical rules. They will tell you that booklet 13, clause number 2 states this and this and this. And I find it puzzling that most of our practitioners don't even know about the existence of the ethical rules. So that is one of the things that we need to be on the lookout for. Obviously, didn't skip it. Okay. Then the next point that I wanted to raise was medical records and documentation. So the National Health Act of 2003 provides that persons in charge of health establishments must ensure that proper health records are kept and controlled in respect of disclosure to third parties. So us as doctors, we have a duty to ensure that health records are accurate and they are also objective. And there actually is an obligation to protect patient records. So sometimes when doctors are reported and we ask for records, we get like half records, or we find that pages are missing. But the most fascinating thing that we sometimes see is how notes are written. Like they just are scribbled. You can't see who signed the actual record, and there's always a debate. I didn't keep this record. It's kept by the hospital. So there's always a whole lot of debate. I'm so glad that most hospitals these days have got like digital health records, which makes it much easier. But the paper records go missing. We also know about the fact that even employees can hide the records or change them sometimes. So you always have to be on the lookout. I mean, this speaks mostly to your own medical records if you are running a practice, but for people who are employed in hospitals or who are in charge of hospitals, you always have to adhere to this medical record keeping. And then maintenance of confidentiality, I deal with it at a different slide. And medical records should always contain objective information. We did a case just recently where it's two doctors. So any examples I use are not going to have identifiers. They don't have provinces where they happen. So they are not related to any specific person. It's just to illustrate a case. So these two doctors were arguing about patient management, and the senior went and wrote in the file to say to the other doctor, I do not understand this diagnosis, and they scratched off the diagnosis, and then they wrote their own notes. So at any given time, I think we should be aware that medical records are actually your medical legal documents. You cannot be writing derogatory or even unsubstantiated observation or even your opinion. It does not matter when it comes to patients' medical files. Medical files are meant for scientific evidence, diagnosis, results, but they are not communication. We sometimes get people reported for writing in the files derogatory statements about each other. And records should never be tampered with. It is a criminal offense. If an error has occurred, errors will occur. We're all human. Just right below, maybe I'll use a dose. Wrong dose, calculated. This is the correct dose. So what we've seen where patients report, because they also get to know these things. Somebody writes a prescription and then discovers that it's probably a wrong dose or is alerted by the nurse. And instead of scratching it out such that it's still visible, they then go and basically interfere with it and change it and write on top of it. That is not even a consideration. So we come, like I speak on the side of trying to guide and showing that there are certain things that we as practitioners should be doing better. Yeah. I think this one was jumped. I don't know how. I'd meant to speak about informed consent in children. I work in a pediatric hospital only, and there's always confusion. So this is merely to remind everyone that children are not small adults, and they generally are assumed to have no competence, no capacity at specific ages. But we all know that the Children's Act actually changed, and there were certain concessions. It's been quite a bit of a debate, especially in the ethics space, that children basically rely on assent by parents and also or their legal guardians. And with legal guardians, we always find difficulty. So when the law says legal guardian, they don't mean someone who lives in your house, somebody who has papers to be able to sign for the child. So us here at the hospital, we are always arguing with grandparents or with aunts who want to sign surgeries for their sister's child. So just be aware that legal guardian means just legal, not relational. Children over 12 years of age, they may consent to medical treatment, including HIV testing and termination of pregnancy without parental consent, provided they have capacity. So if they are mentally handicapped or are so sick that they can't sign consent, they still need their guardians or parents to sign for them. This is a contentious issue. People have taken us on how can a child sign for termination of pregnancy, but they can't sign for an appendicitis. And the issue lies in that this is a legal requirement. So consent for surgical procedures remains controversial. Above 12 years, everyone uses a different age. As I was preparing for this talk, I saw an age of 16, and I saw 18, and I saw 21. So what if you want to cover yourself, anybody who is not considered an adult, at least above the age of 18, then, below the age of 18, if they are going to have a surgical procedure, you need to have a parental assent. Okay. Then I deal with consent during emergencies. There's also a whole lot of discussion around informed consent, because on the one slide, we are saying consent must be voluntary, it must be with full information, but there are situations where a patient is unable to give consent. And if an action is not done, then they will face death or irreversible damage. In that context, the National Health Act provides that no one may be denied emergency care. So basically, you as a doctor in that case, you can go ahead, attend to the patient without consent, as long as at the end of the procedure, you go back and inform family, inform the patient that you had to undergo an emergency procedure. There was a very interesting case. I think it presented also at our prelim. Someone in the Western Cape presented with severe allergic reaction, and the doctor gave adrenaline, and the patient wrote to us and said he did not give consent. So it was quite a debate. Was this an emergency? Was this not an emergency? And eventually our committee said, well, the doctor erred on the side of life. So they did not need to get consent at that time. And I think this consent thing actually confuses our patients so much. I think I was chatting to someone and I asked them that if you are in a hospital, does it mean every time the doctor comes, they must ask you, are you okay if I give you an injection? Is it the doctor's just discretion to give an injection? Because we are beginning to get complaints like that. But those are easy to deal with, because in the line of us doing our duty, there are certain things. For instance, in hospitals, there is what we call a hospital-wide consent, which means you agree to undergo treatments, blood tests, because it's highly impossible that each time you want to take blood from a child, you must call the parents and say, is it okay if I take blood? Blood transfusions still require consent. And in hospitals, there is a way in how you can deal with it. Your superintendent or your consultant on call sometimes can make the call in an emergency. But in a non-emergency, it's better to delay and do them when you can obtain consent from parents. For adults, I find it easy, because if the adult is there, they are awake and they are competent, then they can give you consent. Then I put this line of doctors are obliged to assist in emergency. We received a case again where there was a patient in casualty. And a doctor was called. He was in his rooms, and he refused to come because he said he's busy. If we look at the laws, that doctor should actually be spoken to or investigated, because the only time you can refuse to assist in an emergency is if you are busy with another resuscitation. And this doctor's story was very interesting. He said he didn't want to come because the patient was a cash paying patient and he had patients in his room that were waiting. So I think that for us it's a no-no. We should never delay providing emergency care, particularly if we are occupied in non-emergency situations, and failure to do so may result in a disciplinary or even legal action. So this doctor was brought through by the family because they probably had the conversation with the other doctors that he refused to come because he thought he was not going to get paid. Uh, Communication is one thing also that we've also picked up. This slide actually comes exactly from the ethical guidelines of the HPCSA. We have really tried to address certain things, and this speaks to some of the things that patients read about and they report us for. Privacy must always be respected. Confidentiality and dignity of patients always paramount. I can give an example. We are getting complaints these days that a patient will have done a blood test and they get a call from the PA or from the secretary of the doctor that says, so and so, your HIV test is ready. That is a no-no. Your PAs should not be contacting patients on results. They could rather be calling and saying, please come, your blood tests are ready. But once they start naming tests, that is not acceptable. We also had a case where an SMS was accidentally sent to the mother by the PA, but it actually mentioned the test that the son had done. So the son reported the doctor because he was not ready to tell the mother what he was being tested for. So it's the little things that we do every day that we don't pay attention to. The one thing that we also must do, a whole lot of communication is revolves around patient reporting us for how we communicate with them. Sometimes there is lack of respect. Sometimes we speak down about our colleagues in front of patients, and they then the HPCSA gets to know about it. One of the things that is also becoming quite common is relationships, where a doctor has a relationship with a patient, like a sexual relationship, not just a doctor-patient relationship. And we also do get also issues around exploitative and financial arrangements. And my one thing is, like, at medical school, they never taught us many things about business, but we get doctors getting reported for being involved in investment advice and suggesting to patients which brokers they must use. It might be well and good if it goes well, but once the patients read our own guidelines, they then report to the HPCSA. We always have to guard against the human rights violations of patients, and we are not allowed to participate or condone in any actions that violate to rights of patients. So sometimes in our exhaustion or our frustration, we say things and we speak to patients in a manner that is unbecoming. And unfortunately, I suppose, just like lawyers, just like accountants, society holds us in very high regard. So for that, we always have to try and almost be beyond a reproach. But we all know that we are human, and sometimes I find that you will have an outburst, but you can still communicate with the patient and apologize and let them know that that was not the intention. But what tends to happen, we become very arrogant, and we speak to patients in a manner that they don't appreciate. And we have lots and lots of complaints on communication. Then the next point that we are seeing more and more often from our obstetric colleagues, it's young females with male gynecologists. I'm trying to recall what examples we have. So we had a patient who had stated that they prefer a female gynecologist, and I think the doctor just went ahead and decided to examine the patient without a chaperone, without getting assistance or even thinking about the request of the patient. The patient was upset, and then they reported the doctor to the HPCSA. This is more to safeguard our own, basically to safeguard our male counterparts, because you may be doing your work, but sometimes patients just misconstrue as a violation. So we need to guard against that. And then the patients also have a right to inform, the patient has a right to be informed if you will be having a chaperone in the room, because that also becomes a problem for certain females when there is someone else who they don't expect in the room. So basically, we always have to be conscious about these decisions. And sometimes just chatting to the patient, if you're complaining, say, of lower abdominal pain, you have to explain to them what's going to happen and give them a choice, because then they will allow you, but then they will also report you, which becomes a problem. Then the next thing that we see, I've already touched a bit on confidentiality. I think this is taught quite a lot at medical school. Everybody knows we have to recognize the rights of patients to expect that healthcare practitioners will not disclose any personal and confidential information. We now have the Popeye Act, which has just added to the mix, but confidential information is always been between the doctor and the patient. And sometimes, I don't know at what point, you might find that we have friends who are also doctors, and if we are treating their relatives, it also does not give us a right to disclose that information. So if you want, for instance, let's assume you are treating my daughter, the only way you can give me feedback is if she gives you consent. So we do those violations where we are chatting to another colleague about their relative, and the relative gets to find out, and they really, really are upset, and then they report us. And then certain information can be released if there's a court order, and that's required by law, and it's in the interest of the patient, and then not breach confidentiality without any sound reason and without the knowledge of the patient. And then when we are claiming from medical schemes as well, to the patients, the significance of your ICD codes, and get the permission of the patient to breach confidentiality. We've just had this big case between the CMS and some of the medical schemes. I'm sure everyone has seen it in the media. When you read that case, you can almost see that some of the information was not even supposed to flow out. But it goes for doctors, but it also goes for medical schemes. The biggest risk with this is now a punishable offense. So if you disclose anyone's confidential information, you should know that you're most likely going to get a fine from the HPCSA if they do report you. Okay. Then the next big one is negligence. A whole lot of our profession, they get worried. I've seen even in the hospital where I practice, where people basically start practicing defensive medicine. So I thought I should include this slide to let everyone know how we view negligence as the HPCSA. In doing our duties on a daily basis, we are going to get complications, or things might not go how we expect them. So negligence usually occurs when a patient is either harmed because the doctor failed to exercise the degree of skill and care of a reasonably competent doctor in that sphere or in the profession. And that really says a lot. So if you decide to go against written standards, written SOPs, and you do things outside what is expected of a reasonable doctor, then that is going to be looked at as negligence. And negligence, I think, is probably one of the highest misconduct that we don't view lightly at the HPCSA. Complications that are outside your control are actually not negligence, but how you respond to complications is sometimes what brings people to the HPCSA. In our committee, like you saw, I said we've got a surgeon, we've got an orthopedic surgeon, and we've got an obs and gynae. So we get a whole lot of reports. The wound did not heal properly. That's not the doctor's fault. Wound dehiscence, most of the time, is not the doctor's fault. But especially for the obs and gynaes, when they are doing hysterectomies, now and again, they will nick a ureter. That's still an expected complication of the procedure. The only issue becomes when a patient now post-op is complaining, severe pain, they are not passing urine, and the response is not what we expect. There is no relook. There is no suspicion that maybe I have injured the ureters. Then that becomes what we call negligence. So a test for negligence is usually whether a reasonable person in that position or of the accused ought to have seen the possibility of harm, and they've also taken reasonable steps or guard against harm happening. The fact that harm happened is not good enough. That's negligence, because we all wake up. Nobody wakes up and says, "Oh, today I'm going to suture a wound so that it's gonna get infected." It's in the process of doing your work that the infection is going to happen. So it's not always that we find negligence against professionals, but now and again, we do find negligence, failure to respond. There's a new thing as well where people operate on patients on a Friday and then they're flying out to Durban or Cape Town on the same day. And then complications happen and somebody says, no, but I have handed over to my colleague. You look at the handover notes, it's not even clear what needs to happen. That's the only time where we will find negligence against any professional. Then there's a whole lot of things that we deem as professional misconduct. So any act that brings the profession into disrepute, this is not the whole exhaustive list. Any crime that you commit, there's a very interesting story of one of the doctors that came to see us. Normally, if we don't understand what you have submitted, we invite for a consultation. So the doctor came for a consultation and he was adamant that when he committed the crime, he was not being a doctor. Unfortunately, you can't separate yourself. So if you commit a crime and you are registered with the Health Professionals Council, then you are going to be reported as such. You can't say, oh no, I committed the crime on a weekend when I was off. You will be reported to both the police and the HPCSA. Negligence, I've already spoken about. Overcharging is usually a dispute about prices. That's why when we say informed consent includes fees that you're going to charge. If you are subscribed out of medical aid, please let the patients know. If there's going to be a shortfall, they should know upfront. Patients these days, I don't know, for some reason, they don't take kindly to getting bills to pay. They will tell you that the medical aid has already paid you. And sometimes I feel like it's a disadvantage and doctors are being shortchanged. So there isn't a foolproof way in which you can do it, but discussing fees upfront is one of the most important things. Supersession, we don't see it as much in the private sector, but we have seen quite a bit from the public sector. I think the public sector, there's still quite a hierarchy. Consultant arrives, sees the diagnosis of another consultant. They decide that this consultant doesn't know what they're doing. They start changing notes or instructing registrars to change the diagnosis or medication. All of that can still be done, but there is a way how you do it. If you find that you don't agree with my diagnosis, the best thing is to talk to me, give me your point of view, let's argue it out. But you can't change charts, you can't change people's prescriptions, you can't even decide that the diagnosis is wrong without having had the other person's point of view. Speaking ill of colleagues, we do get complaints like that. It's actually quite discouraged. We tend to be, I don't know, I think maybe everyone who's gone to medical school was the top of their class, then they become specialists, or even if they don't become specialists, they become doctors, and then they want to criticize people's management, or they want to to interfere with how somebody else would have managed the patient. So there are ways in which that we can avoid that. I have seen some hospitals, they have like standard operating procedures, they have ways of communication, they have referral pathways. So there's quite a lot that happens in that space. I've already spoken about participating in unfair business practices. And then the one thing that we are seeing quite a bit is, I don't know if everyone knows that if you are going to hire a locum, you need to see their HPCSA registration. A whole lot of practitioners use locums who are not registered with the HPCSA. And the strangest thing is they are always either reported by medical aides or by patients themselves. So we should just be guiding our profession to say, if you want me to come and locum for you, please, I need to produce my latest registration. We do it in hospitals and it's done every year. I don't see why it can't be done outside the hospital. Yeah, social media. This is a very interesting space. I think most of us who are older practitioners, we are not used to this, but we have seen people giving medical advice on social media. Like I said, my younger colleagues were telling me that we've got doctors who are now influencers. And I've always said it's fine if you're selling hair products or whatever for you to be an influencer. But the minute you start advising the public about medical help or medication or treatment that they need to be taking, then you are encroaching into what is not recommended. So I'm not going to read through every point, but we just need to be aware. This is a HPCSA social media policy that we need to be cognizant about. And if you put anything on social media, you must just know that it's going to go viral and everyone is going to know about it. So the best thing is only use your own personal page for personal stuff, but please do not share stuff that is going to land anyone in. And it's not nice. For the people who sit in prelims, sometimes it's not nice. And you can see that when the doctors come, they are genuine. They were just giving advice, but the public has complained, so we have to respond. Fees dispute, whenever I give this talk, I always say that's the one space that I am not very familiar about. So I speak about it from an HPCSA perspective. So fees for medical services may only be charged by doctors registered with the HPCSA. That's why you can't use medical associates in your practice if they are unsupervised. You can't use unregistered health practitioners. It's a very unregulated space. I've since come to learn that you can charge between 100 and 300%, depending on your contract with medical schemes. That's still well and good. And you can be contracted out of medical aids. The discussion about fees is always vital at the counseling stage and when you're getting informed consent. And before you render any professional service, patients should be informed if the doctor intends charging a higher fee other than prescribed. But like I said, it's a very unregulated space. I don't even think the HPCSA can begin to try and regulate this. And taking fees up front is discouraged. We had a case, I think the doctor had charged the patient, I'll just give a figure, of about 300,000. It was going to be a procedure and did not give a breakdown of what the 300,000 entails. The patient kept insisting, needing the breakdown, and eventually, when he gave the breakdown, the fees and everything else, including hospital, did not cover the amount. And then he was arguing that, but then when he discovered that, he paid the patient back. That's why I think the HPCSA discourages upfront fees. I think this is about my last slide. I started with a disclaimer. I said this is my personal experience with the HPCSA, and I speak on my personal capacity. Just a reminder to everyone, if you receive a complaint from the HPCSA, please do not ignore it. It's not that you have committed a crime. It's just a matter of there's more information required. But if you do not respond, there's actually a fine for that, for basically obstructing the work of the HPCSA. And I had said in the beginning that the HPCSA is a creature of statute. We follow the act. And if you do receive a complaint, the best thing to do is to respond, because if you ignore it, then you still get charged for ignoring it before we even start looking at your matter. I'd like to thank everyone for staying on, and I hope I've shed some light to how the HPCSA functions. And thank you very much.
Thank you very much to you, Dr. Pinky Chirwa, for your very sobering messages. A reminder to all of us practitioners on the fact that we do have HPCSA to protect the public, as the motto says, but also to guide us in the profession. I think it's very important. We've got the CEO of HPCSA with us, and the registrar. I think we are honored to have him in the room today. Dr. Mahome Masike, I think you would like to make one comment, one or two comments. Dr. Masike, you can go on and unmute yourself, please.
I've done so, Dr. Kenichi.
Great, thank you. Go ahead.
Good evening, colleagues. Thank you very much, Dr. Chirwa, for an informed presentation and sharing your experience. I cannot agree with you more. We, as Africa, contribute 25% of the disease burden of the world. And yet, we only have 3% of the workforce to deal with it. So it's not a question of choice. We have to be competent, we have to be ethical, and we have to have the interests of our patients at heart. So we have to do it. It's not like either or. We also have this approach that says, because we are responsible for the standard of education of healthcare practitioners in this country, what is the product we expect out of the system? We expect leadership, like Dr. Chirwa has just demonstrated. We expect scholars. We expect practitioners to be up to date. I'm sure you know we are not so very popular these days because we insist on compliance with CPD. We expect communicators, but from time to time we get what we call factory faults, and they end up going through disciplinary processes. But in closing, Dr. Kenoshi and Dr. Chirwa and colleagues, we need a critical mass of like-minded people to transform society. There is no way that healthcare can be better anywhere in the world. There is no way we can have universal healthcare coverage if the health practitioners themselves are not part of it. Not just as clinical people, but they've got to be there to add ideas as to how it can work better. Thank you very much, Dr. Kenoshi, for inviting me. Thank you very much, Dr. Chirwa and colleagues. I'm sure I'm going to get CPD points as well, and all of us are going to be compliant. Thank you very much. Good evening. And good evening.
Thank you, Registrar. Thank you. Thank you.
We'll make sure of that. Thank you very much. As I pointed out in the beginning, but some of us had not yet joined because I think some were joining us quite a long queue in the lobby. So we apologize for those who joined after this talk had started. But if you got any questions, you can just raise your hand or any comment you'd like to make. You can just raise your electronic hand and we will notice it. Sam will assist me in the background if I miss any hands, and you can then unmute and put your questions orally. But you can also put your questions or comments in the chat box, and we will look out for those, and Dr. Chirwa will respond. But maybe let me start with this one. I think this one is Dr. Chirwa is from Dr. Peter Angura. He says, in some instances, it appears that critical evidence contained in the medical records of the complainant may be overlooked or not given due consideration by members of the preliminary committee. This raises concerns about practitioners being found guilty or potentially potentially incomplete or superficially assessed information. And then he goes on to pose his questions. I will just go through them. He says, there are three of them. He says, what measures are in place to ensure that the decision-making process is both thorough and fair to practitioners, particularly in cases where preliminary findings are later reversed upon further review? Maybe let me take these other questions as well. To what extent is the well-being and safety of the practitioners taken into account, especially when decisions may appear to be made in a manner that could be perceived as casual or lacking in due diligence? I think his last associated question is, what is your perspective on the possibility of compensating practitioners who, after enduring prolonged, costly, and emotionally taxing proceedings, are ultimately found to have no case to answer? You would like to get some respond to that, Dr. Chirwa?
Okay, thank you, Dr. Ginoshi. Thank you for that question. I think it's a very loaded and packed question. It sounds like it's a specific case, but like I had said in the beginning, so the five preliminary committees are always staffed according to one, competence, and two, we try and spread across the disciplines. So I'll say, for instance, it's very highly unlikely that an orthopedic case would go to a committee that does not have an orthopedic surgeon. And then in that space, they become the subject lead. The other people would come in maybe on the ethical side or medical side, but when it comes to technical matters, whether it's a knee operation, you can't send it to a pediatrician. So that is safeguarded already. Then we always have people who are vested in law, and we have our investigators when we sit, and they will go to all the lengths. And I'm not going to say it's perfect, but they go to every hospital, every doctor's notes, and also what you respond to the HPCSA is what is going to be used. So if you have extra notes or extra information that you need to submit, the best thing is you to submit it to the investigators. But I'm confident that I've seen the men and women who sacrifice their time and sit in these committees and deliberate on these matters. And when sometimes there's no consensus, we send this to an expert opinion. And most times the expert opinions are esteemed people who have gone through the ranks, who are academics, who are scholars. So every angle is covered. Human error, does it okay? Yes, it will okay, because we are human. That's why now we have what we call the appeals committee, which is also chaired by people vested in ethics, people, and they will then invite, for instance, if they have a pediatric case and they don't have a pediatrician, they will invite an expert. But whether some cases filter through, that is still possible. I can't claim and say the HPCSA is perfect, but I think where I'm sitting, I'm confident that measures are taken to cover everybody.
Okay, great. Thank you very much. I think I see two hands, one from Dr. Mayani Mweng, and then I'll come to you. I think we also get a hand from a cardiologist, Dr. Musam Mayaisa. Let's start with Dr. Mweng. You can go ahead and unmute yourself and ask your questions or comment. Please go ahead.
Thank you very much. I hope you can hear me. Thank you, Dr. Chirwa, for a lovely presentation. I'm going to just ask two issues that are practical in a state facility. One of them, you were talking about the records and responsibility of the doctors in keeping records. Reality is that, unfortunately, most of our hospitals do not maintain those records very well. And you see it sometimes when you are checking patients that have been left despite trying to document things appropriately. What will be your suggestion under those circumstances where the record keeping is not in our hands, but in the hospital's hands? How should people protect themselves in case they run into problems? The next question, again, when you're looking at some of these state facilities, the ability to have conversations, especially on odd rounds. Obviously, people try their level best not to mention things inappropriately and to show professionalism as best as they can, but you don't always have enough space, and there's a possibility of somebody hearing next to the patient. How much of the reality of the overloaded system will be considered when we are looking at evaluating somebody related to those issues of breach? Thank you.
Thank you very much, Dr. Mweng. Dr. Chirwa, you would like to take that one?
Yes, I'll take that one. Thank you very much, Dr. Mweng. I think that's the reality. The good thing, I've come through those ranks as well. I know exactly about lost records and missing documents, and I understand the challenges. That's why I was distinguishing. If you're running your own practice, then keep your records properly. But if somebody else is a custodian, you have no control. But when we do find the records, even in state, sometimes the records are there, but the notes are very scanty. So the only way you can protect yourself is to write the notes and to the best of your ability. And the record keeping in state is not going to be your function, even in private hospitals, especially now with the POPI Act. There's a discussion whether is it legal for doctors to be photocopying notes and keeping in their offices. And when we consider these cases, for instance, if my committee members are here, maybe they can add. If you, for instance, when somebody reports a registrar or a medical officer, I'm not even perturbed. I'm always saying, where's the supervisor? Who is in charge? Because remember, those are not the ultimate custodians of what happens in the system. And we've got cases where just last week we dismissed a case from somewhere can't remember the name of the hospital in Bloemfontein, where I said, the system has failed these 2 doctors and they are being reported to the HPCSA. So we are considerate. We think so much about the public sector. And just to give you comfort, we were getting our stats, I think about a month ago at the board. They were showing us that about, I think 97% of the cases reported come from the private sector. And that makes about 3% from the public sector, because I think the public is also even sensitive to say doctors in a public system are doing their level best. So that in that case, every matter is considered. And I like our community representatives in these meetings. And most of them are also professionals in their own way. They are the legal minds and whatever. And they, when we get carried away by medical things, they will say, no, 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 hold on. This hospital is in deep rural KZN, and the medical officer is the only doctor that's working. So those things are actually do get taken into consideration.
Thank you very much. I think the next question, Dr. Mayaisa has got his hand up. Dr. Mayaisa, you can go ahead, and then we'll take Professor Christina Lundgren thereafter. Dr. Mayaisa?
Yeah, good evening, and then thank you for the comprehensive presentation, and thanks for leading the platform, Dr. Kinoshi. Mine has to do with the audio recordings. You know, like we do have situations where you are recorded unknowingly. Sometimes they do request permission to record you, as you explain concept. I'm not so sure what is the view of the HPCSA on that, and then what is the status of those recordings? Can they come and produce them later on when they want to use them as weapons, those audio recordings, or not? The second question has to do with the issue of the system. You know, like HPCSA, from what we're taught, it's where the complaints that has to do with practice of medicine and then the issues relating to the profession of medicine goes to. And then we get the leaks lately where the court becomes the first resort, you know, for, I'm not so sure how does those systems harmonize. I thought maybe the courts were supposed to redirect to the CSA process complaints that they relate to our practice. Those are the 2 questions. Thank you.
Thank you very much. You would like to answer that briefly, Doc?
I'm going to attempt to answer. The first one about recordings, that makes me very nervous. I've said it even in the hospital where I work. When patients start recording doctors and recording vitals, I think it comes from a position of not trusting. So unfortunately, I haven't come through any complaint about recordings, but if it's happening, I think the hospital or the individual doctor needs to take a stance. For me, if you record our conversation, it means you don't trust. I think I had asked a legal opinion once on a recording, and they did say that sometimes those can be accepted by courts, provided the intention was to prove something. It's like if you are witnessing a crime and the person will later dispute, sometimes they are acceptable. But as a profession, I would probably discourage it. I wouldn't be comfortable with recordings. And then the one of the police arresting doctors, I think it's not really in my domain, but I think the HPCSA has addressed it fully. And they've written petitions. I think there was also even consultations just to ask that there's no doctor who wakes up and says, today I'm going to murder a patient. But in the process of us carrying out our duties, patients may die. And I think that is unfortunate if it starts at the courts. But remember, the public also sometimes views us as pulling rank and protecting each other. So they really don't trust the HPCSA. So when they open a criminal case, we really have no jurisdiction over that, because now that is in in the law.
Okay, thank you very much, Doc. I think Professor Christina Lundgren has got her hand up, but may I please take this one first from Professor Derek Duplessis? It's been in the chat for some time. I'm hoping that the registrar is still logged in. Dr. Masike, maybe you can also assist in answering this one. Professor Duplessis says, it's a pity that currently the hearings of the HPCSA are primarily driven by lawyers, and they become adversarial processes as if in the courts. Would you like to comment on that? And maybe I'll invite Dr. Masike if you'd like to comment on that as well. Our hearings being driven by lawyers.
Which one? The conduct inquiry?
In the conduct inquiries, not necessarily the preliminaries. I think the preliminaries are usually are professionals only, but the conduct inquiries, in most cases, actually chaired by lawyers or sometimes chaired by lawyers, but they have also professionals as well in the conduct committees. So I think that's what he's referring to. Would you like to comment on that?
Yeah. I think once it goes to conduct inquiry, that's always been my understanding, then it's a serious misdemeanor. So it means you as a doctor are also allowed to have legal representation, and the HPCSA also comes with their own lawyers, because I think there wouldn't be balance if you come with your lawyer to be speaking to other doctors. Conduct inquiries are a totally different process that I explained here. They serious, they look at matters where there are proper cases to be answered. What tends to happen at prelim, if we find that, for instance, there was the example I made, hiring an unregistered doctor, we don't even send it to conduct inquiry, because it can be fined at prelim level. But if there is a crime, like there's fraud, it becomes very difficult to end it at prelim. It needs to go to conduct inquiry, and the rationale is that conduct inquiry has got much more resources and they've got more people vested in the law where they can look at these cases. The fact that the chairperson is a lawyer, I can't answer for that. Maybe Dr. Masike can. But I know that when I have been invited to conduct inquiries, I would be there for the HPCSA board, but also can give guidance on medical subjects. I'll try and see if we can find something. Maybe we'll probably respond through Clinix, but I still feel that I think the lawyers are required at conduct inquiry because of the nature of the.
That's right, and the consequences are more serious. They are actually disciplinary hearings, and most of the cases that go to conduct inquiry have gone through preliminary committee before, but then the preliminary committee then refers them to a higher level, or let me just say to take a disciplinary committee, which is called a professional conduct inquiry. I think maybe our practitioner colleagues could read more the ethical guidelines and ethical rules that are contained in the booklets, and quite a number of booklets are numbered, and let me put it that way, and they are all in the HPCSA website. Am I right, Dr. Chirwa? I think if we could all access them and read them for our information, we would know how.
There's a lot of information, and like the public can also access it. That's why when they report us, they will even know the page and the clause and the booklet where they found that doctors are not allowed to do 1, 2, and 3. And I heard someone saying that they are, what did they say? They are guidelines, but if you read them, they actually are rules. So it means they need to,
That's right. And I think the public should not know more about them than we, the practitioners. So we need to access them. They are available on website free of charge. Professor Christina Lundgren, you can go ahead, please. My apologies for you waiting this long. We have another hand, but we'll come to you first, Prof. Go ahead.
Thanks, Dr. Kenoshin. Thanks, Dr. Chirwa, for an excellent lecture. I haven't got as much experience as you on MDB, and I'm on Prelim 5 and one of the appeals committees, and I'm shocked at a few things. First of all, and I'm glad you talked a lot about informed consent. I mean, the quality of consent for various procedures, for anesthesia, for surgery is, I'm absolutely shocked. So I honestly think we all need to take a step back and say, you know, are our patients giving informed consent? Secondly, I'm quite taken aback at how many doctors there are who don't have indemnity insurance. So they get reported to the HPCSA. They reply in their own capacity, and if it's a serious misconduct issue, they're kind of on their own if they don't have lawyers to support them, or they have to pay out quite a lot of money for lawyers. And I see there are a lot of questions about how fair are the prelim committees and how fair is the process. On the appeals committee, it's an awful lot of work to go through the prelim findings, the appeals and then the appeal from the complainant. But we actually get specialists in for each individual complaint. And so I am impressed by how fair the process is. First at prelim, I'm on prelim 5, and secondly, the appeals process. So, yeah, I can't comment on the disciplinary hearings, but I do think that it's a very fair process to all the people who have asked how fair it is and how everybody deliberates, etc. And we always have a legal opinion in our meetings. So, but thank you for a fabulous lecture.
No, thank you very much, Prof.
Thank you very much.
And
thank you very much, Prof.
I wonder if the doctors also know that our meetings are recorded. I've seen people asking for the recordings.
Yeah.
There's a very popular case where the person asked for a recording, took the matter on appeal to the courts and lost still. And some of the lawyers who had listened to the deliberations were actually surprised that everyone's voice is heard and it's done in a fair manner. So sometimes when people are found having conducted themselves unprofessionally, it's actually true. Because when you hire an unregistered doctor, we can't even argue. It's in the rules of the HPCSA. Anybody who touches patients must be registered. It doesn't say they must be qualified to be doctors. It says must be registered with the HPCSA. So maybe 99% of the time, if the verdict or the assumption is that there is wrongdoing, there actually is. And Prof. Langren can tell you from the appeals, because they also show us statistics. Like I said, most of the prelim findings are actually sometimes upheld at the appeals. So very few come back for us to rethink. And sometimes when they do come back, it's because new information has surfaced.
Okay, thank you. There are quite a number of questions in the chat box. I'm not sure whether we'll be able to go through all of them. We're already at 1931, but we will see how far we go. But there is a hand from, I think there was a hand before Dr. Machache. There was a hand from Dr. Tlagani. I think it's Dr. Sipogazi Tlagani first, and then we'll come to Dr. Machache. Dr. Tlagani, you can go ahead. briefly.
Good evening. Good evening, all, and thank you so much for this detailed presentation, Dr. Chirwa, and to the Clinix group. I'd actually put this question in the chat, but I also see that it came up quite a bit as a repetition. In terms of confidentiality, we tend to get quite a few requests from the funders, from the medical schemes now requesting patient medical records, including their notes. And they are citing some Council of Medical Schemes Act 15, which I absolutely have no idea about. But what would be the view of the council when it comes to that, in terms of doctor-patient confidentiality? Because sometimes the information that is in those notes, I am of the view that shouldn't be going to an auditor who's not a medical person, who's not going to use it for what it's intended for. Thank you.
True. No, thank you very much for that question. We also see it where now doctors get reported, and now they are reported by schemes, and we don't even look at it if there's no patient consent. So the same rules apply. The patient needs to know what they are consenting to. Are they consenting to see what were they charged? Are they consenting for the medical schemes to see the diagnosis, which would be in the ICD codes? But for me, the first stop is patient must give consent. Medical schemes, I was just so disgusted by this case that we've been seeing, will not bully doctors to get patient information without patient consent. And that's my view.
Thank you very much. I think let's take a question from your colleague, Dr. Machache. Dr. Machache, can go ahead. Is your audio, Dr. Machache? Try again.
Can you hear me now?
Now we can hear you clearly. Can go ahead, Doc.
Yeah, thank you very much, Dr. Kinoshi, and thank you very much, Dr. Chirwa, for a very informative talk. I'd also put my question in the chat box. When we're talking about fees at consultation, we have issues problems where, where a mother is pregnant and has got a baby who's not covered by medical aid. So after the delivery, when you see the patient and then the baby, the mother says, look, I was not informed about your fees and so on, and it causes a lot of distress to the patient and also to the doctor. So I wanted to find out, is there any obligation on the obstetrician during antenatal care to discuss with the patient the fees for the pediatrician? They do discuss the fees of the anesthetist where Caesar is required, but not for the pediatrician. So I wanted to know, is there any ethical obligation on the obstetrician to do so? Thank you.
No, I don't think there is an ethical obligation because everyone has to discuss their fees. But I'm assuming that and you'll forgive me on this space, this is a space I'm not familiar with. Do you have like a chosen pediatrician before delivery? Because maybe then that's when the fees can be discussed. But it's very difficult to discuss fees once the baby is born, particularly those third generation. I've heard just recently where there was a patient that is a third generation and cannot be covered by medical aid. So I assume, anybody else can answer that one. It's something that I'm not familiar with, but I doubt it would be ethical to discuss fees because I'm just assuming which pediatrician, if maybe they just wait for the roster. So it's okay to discuss the fees after the baby is born, and patients are still obliged to pay your fees if you have rendered a service. You can't render a service for free, but I doubt you can discuss fees before the baby is born.
Okay, thank you.
Okay, that's right. Yeah, and what happens, Doc, in the case of third generation babies, where the mother is a daughter of a lady, so the daughter is pregnant, is in labor, it gives birth to, so the mother is covered, but the baby who's now being born is not covered in the grandmother's medical aid scheme. Can that be discussed before delivery?
I don't think so. I don't think
Yeah,
so.
but why not? I mean, I think would the pediatrician be wrong to inform the member, medical aid member, that is the grandmother in this case, to the newborn, that the baby will not be covered unless, of course, if you make arrangements with the medical aid scheme and ensure that whether the mother will be covered or not, so that they are not embarrassed to find out after the delivery that actually they have to pay from their pockets. I'm not sure.
I think that can be discussed because that would be known already. And
Yeah.
just by virtue of the grandchild, you already know that that one's not going to be covered. So, and the discussion of fees is not, I mean, like I said, the upfront fees are the ones that are sort of discouraged, but they can be done if you break down your fees.
Yeah.
What we
In
tend
other
to
words,
see is just a round figure that says, I'm going to be charging this much, but there's no accounting of what is it for. So the patients want to know the breakdown, and they want to know that if there's any money left over, are you going to return it?
Okay. Yeah, sort of a quotation. All right. Yeah, it's a tricky one, but it's often done in the private sector that, the hospitals and specialists do give a sort of a guide to the patient of how much the whole account might end up being. But it's a tricky one, though. But I think let's take 4 or 5 minutes just to answer, to ask one or two questions. I think the rest of the questions that are in the chat box, we will send them to, and Dr. Chirwa can respond at her own pace to those who have posed questions. We've got your email addresses. And if you have any other questions that were not covered today, you can still send them to webinars@clinix.co.za for the attention of Dr. Chirwa, and we'll make sure that they get to her. We will also, there are one or two insights in the chat box that I saw, whether they are asking whether your presentation will be available to them. So our policy on presentations to attendees is that they should request them. So those who request on webinars@clinix.co.za, we will then request the presenter, who today is Dr. Chirwa, and only if Dr. Chirwa agrees, then we post them, we email them to the people who request a copy of the presentation. But you can send your request to webinars@clinix.co.za. And Dr. Chirwa, there's a question that's from Dr. Leslie Ramya, and he says, can doctors refuse to treat patients if it's not an emergency?
I think it needs context. I'll just use an example that we find. So same as the patients have rights, doctors also have rights. And sometimes when we've seen a rude patient basically abusing a doctor. So if you go to our guidelines, it says you are not obliged to treat that kind of patient, but you can refer them to, if they've come to see a gynae, you can refer them to another gynae of a similar skill. So they can refuse to treat patients. But it's very rare occasions where you will refuse patients, because remember, the patient doctor relationship is almost like a contract. So you can imagine already if a drunk patient comes and abuses you in your surgery, I think that would be unfair. But generally, the issues that we find are during emergencies, but there are circumstances where a doctor can refuse to. There are guidelines to that. I just can't remember what booklet where it tells you that you're not obliged to treat a patient who's disrespectful to you, or we've had patients, for instance, for religious reasons, who will not doctors who can't do an abortion due to religious reasons, and the law allows them to refer that patient to someone who's similarly qualified. So the short answer is yes, but it has to have context.
Yeah, there's a there's a question from someone, Dr. Lekalakala, Mapulana Ophelia Lekalakala, which says, are we compelled to examine adult patients under duress by their partners, even when not comfortable? In other words, a couple comes in and one spouse asks you to examine the partner under duress. I suppose they mean that the one who's supposed to be examined is not willing to be examined, but being forced to be examined. Dr. Lekalakala, can I unmute and explain my question if I'm misunderstanding it? Okay, but that's what it appears that's how it appears in the chat box. Dr. Chirwa, you can go in and respond.
No, I'm saying no, because remember, patients have autonomy. So unless the patient is unconscious, but a patient that is competent and has capacity to ask for medical help for themselves should never be forced onto a practitioner by a partner, no.
Yeah, I believe so too. Professor Makunyani, Professor Priscilla Sipati Makunyani is asking, what advice will you give to doctors on involving patients from religious groups that refuse blood or blood products? Are there best practices to help?
Yes, there are best practices to help. So there are guidelines. They also speak to what I touched a little bit on about informed consent and informed refusal, and the approach, because when I was still working in the neonatal ward, was always saying that the baby has no religious choice, but the baby still has to live with the parents. So what we would do would follow certain guidelines. The one resource that we found is one of the I don't think they're called priests, maybe they pastors. They have a document that they come with, and they assist you in terms of, it's the things that we know as medical people, how to conserve blood, not to take bloods every day. They would say you can give like supplements, but there comes a time when it becomes critical. Let's say you are in a neonatal ICU or even a pediatric ICU, and the patient is not doing well because they are anemic, or the blood count has dropped below what you would expect. Then you become the advocate for the patient. But even with that, you have to follow the law. This day, a few years ago, you would have to go and find a magistrate and get a court order. These days, you tell the parent to interdict you, basically, to go get a court order that says you must not transfuse the child. And in an emergency situation, you just err towards the side of life. Yeah, but that space has been navigated quite a lot. It's not as bad as when we were training as pediatricians. I think there is also a case, I think it was Senton, or I always confuse Senton and Morningside, but it's a very well-known case where the doctor actually won the court order. So there is precedence that has been set. So we always just refer to that case. But the guidelines are actually quite interesting.
Thank you very much, Dr. Chirwa. I think we'll take the last one, and I think the rest we'll deal with them the way I've described it earlier, that they will be responded to via email. We can never exhaust questions on this topic, and we actually, it comes to my mind that maybe if after a few months we'll arrange another one like this on ethical rules and guidelines for our practitioners. But let me take this last one before we close. This is from Dr. Stanley Mhlongo. I think if it's a Stanley Mhlongo, I know. Hi, Stanley, from BH. Can a practitioner decline a request from patient or guardian to get another doctor to take over the care? In other words, can a doctor refuse when your patient asks for a second opinion or referral to another doctor?
No. Remember, patients have rights. So, and second opinions are actually embedded in those rights. The one thing that always sorts things out is communication. Because sometimes when patients are asking you for a second opinion, it's either they have no trust or they are doubting something. And we find, maybe you too, Dr. Kinoshi, a space where now patients also have relatives that are doctors, and the doctors want to co-manage from home. So we navigate that space by just having conversations and saying, this is what I found, this is what has happened, this is my plan. And they always take your plan and go and verify it with their relative who's also a doctor. That's well and good. But should they want a second opinion, I don't think you can deny them.
Okay, thank you very much. I think this was very useful. I see there's one last hand coming up. Maybe, I don't know, maybe the chats we can respond to later, but hands, I suppose we should respect them. Has the hand gone down? Just when I was about to recognize it. I think, unless if you've changed your mind, I was going to take your hand. But I think at this stage, I think, like I said, we can't exhaust all these questions, and but we will respond to those that are in the chat box that I have quite a number of messages of gratitude to you, Dr. Chirwa. You'll see them in the chat box saying what a wonderful and informative presentation they've enjoyed it. I'm going to ask Professor Vela P. Professor Stembiso Vela P., who is a fellow pediatrician for you, with you, and colleague of yours, head of pediatrics and child health at Vets and Krisani Bara Academic Hospital. Professor Vela P. is going to thank the speaker and the attendees on the behalf of Clinix. Prof. Vela P.
Good evening, Dr. Chirwa. Good evening, Dr. Kinoshi, and good evening to all the listeners. And thank you so much, Pinky, for this comprehensive talk, which is very informative and talking to our lives. And I think that's why they've got so many questions that have come up, because some of us have been affected one way or another. And I think it was good that you sharing from your own experience while you're serving all of us in the council. The talk was quite comprehensive and quite informative. and it covered quite a number of areas, including the informed consent. It's quite interesting. I did not know this, that part of informed consent, you have to say how much you're going to pay for this procedure. And now I'm going to ask for that when I go and consult to say, how much am I going to pay for this ECG? Or if you say I must do that, if you put me on the scale, I'm going to charge me for my weight. Thanks for all that. And I think you have highlighted the importance of communication, the importance of record keeping, and I think which many of us tend to overlook and we only realize when we're having challenges. And I think colleagues have highlighted the many challenges that we face in the public sector regarding keeping those records. And I think you've advised us as to how to deal with that in terms of making sure that we document everything thoroughly. And thanks for clearly answering all the questions extensively and covering all the areas and giving examples. So really appreciate what you have done for us this evening. And thanks to the colleagues and thanks to everyone who have joined and thanks for your questions because your questions make this evening very rich because coming up with those questions also makes us learn more and also get more from the speaker. We really appreciate that. We really appreciate your presence. And thanks, Dr. Kinoshi, for leading us every Thursday on this webinars, and thanks to Clinix for sponsoring them. And hopefully all of you, wishing all of you a very good evening. Thank you very much.